This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So it appears that the One America Network has sued Rachel Maddow over a story called Trump's New Favorite Channel Employs Kremlin-Paid Journalist. She says that one of the reporters was on the payroll of the Kremlin's official propaganda outlet, Sputnik. And let's see what the court has to say about this. This is an order granting defendant Rachel Maddow's special motion to strike. So this means that when she wins a special motion to strike, Herring Networks will designate a champion. And Rachel Maddow will get to stand face-to-face in the courtroom. The courtroom will construct a special ring, and Rachel Maddow will stand right in front of Herring Network's champion, and she will wind up with the most strength she can muster, and she will slap Herring Network's representative, their champion, in the face as hard as she can. You know, a physical slap to the face. This is a very little-known part of law called a motion to strike. Of course I'm kidding. Let's see what the judge has to say, and we'll figure out what a motion to strike is along the way. Plaintiff Herring Networks filed a complaint for defamation against Rachel Maddow, Comcast, NBC Universal, and MSNBC. The claim stems from a statement that Rachel Maddow made on The Rachel Maddow Show on MSNBC. Defendants filed a special motion to strike pursuant to California Civil Code, commonly known as the Anti-Strategic Lawsuit Against Public Participation, or Anti-SLAPP law. So it's actually quite the opposite. It's Herring Networks that is trying to slap Rachel Maddow, and she's filing a special motion to strike under the anti-SLAPP law so she does not get slapped. We'll get to it. The court held oral arguments May 19th, and the court grants defendants' motion to strike. Plaintiff Herring Network owns and operates One America News Network. On July 22nd, 2019, reporter Kevin Poulsen his name was Robert Poulsen. His reporter Kevin Poulsen at the Daily Beast published a story, Trump's New Favorite Channel Employs Kremlin-Paid Journalist. Poulsen reported that Christian Roez, okay, so not Rachel Maddow, but Christian Roez, one of the reporters at OAN, was on the payroll of the Kremlin's official propaganda outlet Sputnik. In short, Poulsen reported that Rouz has been reporting on U.S. politics for OAN since August 2017, and for all of that time, he's been simultaneously writing for Sputnik, a Kremlin-owned newswire that played a role in Russia's 2016 election interference operation, according to an assessment by the U.S. intelligence community. Poulsen opined that Kremlin propaganda sometimes sneaks into Rouz's segments on unrelated matters and provides examples. Poulsen also quoted former FBI agent Clint Watts, who stated that this completes the merger between Russia state-sponsored propaganda and American conservative media. We used to think of it as they just have the same views, or they just use the same story leads, but now they have the same personnel. And I think this is supposed to be LEDES. Later that day, Rachel Maddow discussed the Daily Beast article with her talk show friends on The Rachel Maddow Show, which airs on MSNBC. The segment was titled Staffer on Trump-Favored Network is on Propaganda Kremlin Payroll. Available here at this link. Maddow opened the segment by informing viewers about OAN, calling it a boutique little news outlet that is specifically designed for Trump mega fans. She pointed out that President Trump previously praised OAN's ratings on Twitter and gave OAN a press pass to the White House. Maddow then stated that she has the most perfectly formed story of the day and presented Kevin Poulsen's Daily Beast article. She stated that the article reports that OAN, which is Trump's favorite, more Trumpier than Fox TV network, has a full-time on-air reporter who covers U.S. politics who is simultaneously on the payroll of the Kremlin. The reporter is being paid to produce pro-Putin propaganda for the Russian-funded network Sputnik. Maddow states there is a lot of news today, but among the giblets the news gods dropped off their plates for us to eat off the floor today is the actual news that this super right-wing news outlet that the president has repeatedly endorsed. We literally learned today that the outlet the president is promoting shares staff with the Kremlin. I mean, what? She laughs and soon after says, in this case, the most obsequiously pro-Trump right-wing news outlet in America is really, literally paid by Russian propaganda. Their on-air U.S. politics reporter is paid by the Russian government to produce propaganda for the Russian government. The underlined portion of the sentence highlights where plaintiff takes issue. Plaintiff sued for defamation over this really literally is paid Russian propaganda. Soon afterwards, defendants filed the present motion. California's anti-SLAPP statute is intended to provide a procedural remedy to dispose of lawsuits that are brought to chill the valid exercise of constitutional rights. So in other words, everyone out there who claims First Amendment protections, this is it. This is the kind of lawsuit that would chill First Amendment protections, and so an anti-SLAPP law is appropriate. It provides a cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the Constitution of the United States or California in connection with a public issue shall be subject to a special motion to strike unless the court determines that the plaintiff has established that there is probability that the plaintiff will prevail on the claim. Courts apply a two-step analysis to determine whether an action is subject to an anti-SLAPP special motion to strike. First, the defendant must establish that the challenged cause of action is one arising from protected activity. Once the defendant makes a showing that the act is protected activity, the burden shifts to plaintiff, who must establish a probability of prevailing on the claim. For purposes of the federal rules of civil procedure, a motion brought on anti-SLAPP grounds can either be analogous to a motion to dismiss or a motion for summary judgment. Here, defendant's motion is analogous to a motion to dismiss because defendants move to strike based on legal arguments as opposed to factual findings. Defendants are not providing alternate facts to challenge the allegations in the complaint, so the motion is not analogous to a motion for summary judgment. Summary judgment would be a factual determination at the end of the court case. The parties having made their legal and factual arguments, if there's no genuine dispute of fact at the end, then the court doesn't have to take the thing to a trial via jury for fact finding, and the court can make a determination as a matter of law. But we're not at that stage. We're at the beginning. We're at the motion to dismiss stage, so it acts like a motion to dismiss. The issue then becomes what the court may consider in evaluating the present motion. For the second prong of the anti-SLAPP test, to show a probability of prevailing on the merits, a plaintiff must demonstrate the complaint is legally sufficient and supported by a sufficient prima facie or basic case showing of facts to sustain a favorable judgment if the evidence submitted by plaintiff is credited. In making its determination, a court shall consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. The Ninth Circuit has noted that there are conflicts between California's anti-SLAPP law, its procedural provisions, and the federal rules of civil procedure. If there is a contest between a state procedural rule and federal rules, the federal rules prevail. Specifically, when a court considers a motion to strike based on alleged deficiencies in the plaintiff's complaint, the motion must be treated in the same manner as a motion to dismiss under 12b-6. Plaintiff attaches various declarations and exhibits to its opposition brief. Plaintiff also moves ex parte to supplement the record with an episode of Hardball by Chris Matthews, which aired on MSNBC. Because defendant's motion is analogous to a motion to dismiss, the motion must be treated in the same manner as a motion under 12b-6. In evaluating the motion, courts consider the complaint as well as material which is properly submitted as part of the complaint, which means the documents are either physically attached to the complaint or the complaint necessarily relies on them and their authenticity is not contested. Even if a document is not attached to a complaint, it may be incorporated by reference into a complaint if the plaintiff refers extensively to the document or the document forms the basis of plaintiff's claims. The court finds it appropriate to incorporate by reference the Daily Beast article as well as the relevant segment of the Rachel Maddow show. Both are referred to extensively in plaintiff's complaint. The court declines to consider the declarations and exhibits submitted by plaintiff and the hardball video, as this information is not attached to the complaint, relied on by the complaint, or judicially noticeable. The court therefore denies plaintiff's ex parte motion. Defendants have the burden to establish that Maddow's actions alleged in the complaint arise from protected activity. The law sets forth 4 categories of protected activity. E4 defines protected activity to include any conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or issue of public interest. The public interest requirement is construed broadly to include any issue in which the public is interested. Plaintiff agrees that Maddow was exercising her constitutional right of free speech and her statements concerned a public issue. Thus, plaintiff does not contest that the first prong of the anti-SLAPP statute is met. The court agrees and will turn to the second prong. In the second step, plaintiff must show reasonable probability of prevailing on the challenged claim. Plaintiff is suing for defamation. Under California law, defamation involves the intentional publication of a statement of fact which is false, unprivileged, and has a natural tendency to injure, or which causes special damage. In arguing that plaintiff cannot prevail on the merits of its claim, defendant makes two arguments in the alternative. First, Maddow's statement is one of opinion and not of fact. The statement is not defamatory. And second, the statement is substantially true. The threshold question in a defamation claim is whether a reasonable fact finder could conclude that the contested statement implies an assertion of objective fact. If the answer is no, the claim is foreclosed by the First Amendment. This is because pure opinion, that is, statements that do not imply facts capable of being proved true or false, is protected. To determine whether a statement implies a factual insertion, the court must examine the totality of the circumstances in which the statement was made. The court looks at the statement in its broad context, which includes the general tenor of the entire work, the subject of the statements, the setting, and the format of the work. Second, the court considers the specific context and content of the statements, analyzing the extent of figurative or hyperbolic language used and the reasonable expectations of the audience in that particular situation. Finally, the court considers whether the statement itself is sufficiently factual to be susceptible of being proved true or false. Whether an allegedly defamatory statement is one of opinion or fact is a question of law. But if a statement is susceptible of different constructions, one of which is defamatory, resolution of the ambiguity is a question of fact for the jury. The court turns to the three factors under the totality of the circumstance analysis. Broad context can be determinative that a statement is opinion and not fact, for the context of a statement may control whether words were understood in a defamatory sense. The court first considers the medium in which the statement was made. Maddow made the statement on her talk show segment that aired on MSNBC. The more statements lack the formality and polish typically found in documents in which a reader would expect to find facts, the more likely the statements are non-actionable opinion. The court may consider whether the forum is one where a reader would be likely to recognize that statements generally represent the highly subjective opinions of the author rather than assertions of verifiable objective facts. On one hand, a viewer who watches news channels tunes in for facts and the goings-on of the world. MSNBC indeed produces news, but this point must be juxtaposed with the fact that Maddow made the allegedly defamatory statement on her own talk show news segment, where she is invited and encouraged to share her opinions with her viewers. At least according to plaintiff, viewers who watch MSNBC may know that it carries a liberal message and that Maddow is a liberal television host who expresses her views regarding Russia and President Trump. Maddow does not keep her political views a secret, and therefore audiences could expect her to use subjective language that comports with her political opinions. Thus, Maddow's show is different than a typical news segment where anchors inform viewers about the daily news. The point of Maddow's show is for her to provide the news, but also to offer her opinions as to that news. Therefore, the court finds that the medium of the alleged defamatory statement makes it more likely that a reasonable viewer would not conclude that a contested statement implies an assertion of objective fact. The court now turns to the segment as a whole. The general tenor of Maddow's segment is a report on the Daily Beast article, and Maddow's tone could be described as surprise and glee at the unexpectedness of the story. She begins by calling the story the single most, sparkly story in what had been a more ridiculous than most day in the news. She calls the news, one among the giblets of news gods dropped off their plates for us to eat off the floor today. Maddow reports that OAN shares staff with the Kremlin and discusses the allegedly defamatory Russia connection, then follows this by saying, while laughing, "I mean, what?" She concludes the segment by saying, with a shake of the head, "I mean, this is the kind of news we are supposed to take in stride these days, and we do our best." When, as here, an author writing about a controversial occurrence fairly describes the general events involved and offers their personal perspective about some of the ambiguities and disputed facts, their statement should be generally protected by the First Amendment. Otherwise, there would be no room for expressions of opinion by commentators, experts in a field, figures closely involved in a public controversy, or others whose perspectives might be of interest to the public. Instead, authors of every sort would be forced to provide only dry, colorless descriptions of facts, bereft of analysis or insight. There would be little difference between the editorial page and the front page, between commentary and reporting, and the robust debate among people with different viewpoints that is a vital part of our democracy would surely be hampered. This is true here too. Maddow fairly described the article that formed the basis of her segment. She added in her colorful commentary and opinions. Viewers expect her to do so, as it is indeed her show, and viewers watch the segment with the understanding that it will contain Maddow's personal and subjective views about the news. Thus, the court finds that as a part of the totality of the circumstances, the broad context weighs in favor of a finding that the alleged defamatory statement is Maddow's opinion and exaggeration of the Daily Beast article, and that reasonable viewers would not take the statement as factual. The court now considers the specific context. Even where the broad context is one of opinion, it is possible that a particular statement may imply an assertion of objective fact and thus constitute actionable defamation. In analyzing the specific context and the content of those statements, the court analyzes the extent of figurative or hyperbolic language used and the reasonable expectations of the audience in that situation. Where the language used is loose, figurative, or hyperbolic, this tends to negate the impression that a statement contains an assertion of verifiable fact. A hyperbole is an exaggeration, especially to an excessive degree, or in a manner of speaking that depicts something as being much bigger, smaller, worse, etc. than it really is. Hyperbolic statements are not actionable because the listener knows that he or she should not accept the statements as fact. The primary rationale behind precluding liability for statements that qualify as rhetorical hyperbole is that the listener or reader knows that the statements are not to be taken literally, and therefore such statements do not damage the subject's reputation. A main issue here is whether Maddow's statement was hyperbolic. Because Maddow used the word literally, OAN is literally paid Russian propaganda, plaintiff asserts that it would be unreasonable to find the statement to be hyperbolic. What is noteworthy about the word literally is its conflicting definitions. The first definition is the use of a word in a literal sense or manner, such as in a way that uses the ordinary or primary meaning of a term or expression, or is used to emphasize the truth or accuracy of a statement or description. But the alternative definition is, in effect, virtually, used in an exaggerated way to emphasize a statement or description that is not literally true or possible. Further, under either definition, the term can lose its meaning when considered in context. Although Maddow used the word literally, this does not necessarily mean the phrase should be taken to be factual. Nowadays, as evidenced by the two conflicting definitions of the word literally, the use of the word can be hyperbolic. The court must therefore consider the language surrounding the allegedly defamatory statement to put into perspective the content of the statement. There are certainly facts presented in the segment that are not in dispute. It is undisputed that the Daily Beast article was published, wherein the author, Kevin Poulsen, opined that Christian Rouse has been reporting on U.S. politics for OAN and simultaneously writing for Sputnik, a Kremlin-owned newswire. Rouse is a Russian national on the payroll of Sputnik. Poulsen then detailed a few of Rouse's reports for OAN, pointing out that Kremlin propaganda sometimes sneaks into Rouse's segments. Poulsen found no disclosure by OAN of Rouse's work for Russia's state-owned media, where he continues to file stories daily, primarily on economic news. There is no dispute that Maddow discussed this article on her segment and accurately presented the article's information. Indeed, the facts in the title of her segment are not alleged to be defamatory. Staffer on Trump-favored network is on propaganda Kremlin payroll. Plaintiff agrees that President Trump has praised OAN, and Rouse, a staffer for OAN, writes articles for Sputnik News, which is affiliated with the Russian government. Rouse is paid for his work by Sputnik News. Maddow provided these facts in her segment before the allegedly defamatory statement. The Ninth Circuit has held that when a speaker outlines the factual basis for their conclusion, his statement is protected by the First Amendment. The basis for Maddow's allegedly defamatory statement is clearly the story from the Daily Beast, which she presents truthfully and in full. Thus, she sufficiently provides listeners with the factual basis for her statement. She does not even hint that her opinion is based on any additional undisclosed facts not known to the public. Viewers were presented with the details of the story before hearing the allegedly defamatory statement, and no additional facts were implied. Plaintiff argues that Maddow did not present the full story, namely that Rouse has no decision-making authority with respect to the content that is aired on OAN, and was merely a freelancer for Sputnik News. But the Milkovich case does not require the author to include every possible fact before giving an opinion. Maddow accurately presented the Daily Beast article and the basis for her statement. These facts were true and not misleading. Even if Maddow left out certain information, this does not necessarily mean her statement was defamatory. She did not imply a knowledge of facts which led to the conclusion that her statement was factual. Further, in the sentence immediately following the contested sentence that OAN is literally paid Russian propaganda, Maddow said, almost as a clarification, that OAN's on-air U.S. politics reporter is paid by the Russian government to produce propaganda for that government. And at the time Maddow made the allegedly defamatory statement, the screen was showing the Daily Beast article accompanied by the text. One of the on-air reporters for the 24-hour news network is a Russian national on the payroll of the Kremlin's official propaganda outlet Sputnik. Thus, Maddow immediately qualified the allegedly defamatory statement with a factual clarification, and viewers were seeing accurate information regarding OAN on the screen while listening to Maddow. In the Cochran case, the New York Post published a column wherein the author discussed Johnny Cochran and his defense of O.J. Simpson. In the column, the author stated that history reveals that Cochran will say or do just about anything to win, typically at the expense of the truth. Cochran sued for defamation. In analyzing the statement, the court noted that the specific context of the statement is a collection of opinions colorfully expressed, which renders the statement at issue simply more rhetorical hyperbole. The language of the column was loose, figurative, and hyperbolic. The audience would reasonably expect the alleged defamatory statement to constitute opinion, tucked in as it is among numerous other statements of opinion in a recognizable opinion column. The court concluded that a reasonable fact finder, a jury, could not conclude that the statement at issue is sufficiently factual to be susceptible to being proven true or false. Here, Maddow has inserted her own colorful commentary into and throughout the segment, laughing, expressing her dismay, saying, "I mean what?" and calling the segment a sparkly story, one that we must take in stride. For her to exaggerate the facts and call OAN Russia propaganda was consistent with her tone up to that point, and the court finds a reasonable viewer would not take the statement to be factual given this context. The context of Maddow's statement shows reasonable viewers would consider the contested statement to be her opinion. A reasonable viewer would not actually think OAN is paid Russian propaganda. Instead, he or she would follow the facts of the Daily Beast article that OAN and Sputnik share a reporter, and that both pay this reporter to write articles. Anything beyond this is Maddow's opinion and her exaggeration of the facts. In sum, when the total context surrounding Maddow's comment is considered, the court finds that the context weighs towards a finding that the statement constitutes opinion and rhetorical hyperbole protected under the First Amendment. The court last considers whether the statement is susceptible of being proven true or false. In Unsworth v. Musk, a case we covered at length, the court evaluated a plaintiff's defamation suit against Elon Musk, where the plaintiff brought the case because Musk had issued a tweet calling the plaintiff a person who abuses children. In evaluating the plaintiff's defamation suit, the specificity under the factor of susceptibility of the statement being proven true or false, the court found that defendant's tweets were susceptible of being proven true or false because plaintiff either is or is not what they were accused of being, and if he were, evidence could prove it. Further, the Ninth Circuit in Yagman discussed the plaintiff's use of the term dishonest when describing a judge, and the court found that the statement was of rhetorical hyperbole, incapable of being proved true or false. In contrast, the plaintiff's statement that the judge was drunk on the bench was one that implies actual facts that are capable of objective verification. Here, taken in isolation, the statement that OAN is literally paid Russian propaganda is capable of verification. Either OAN receives money from the Russian government or it does not. Thus, this factor weighs in favor of a finding that viewers could conclude that the statement implied an assertion of objective fact. By protecting speakers whose statements cannot reasonably be interpreted as allegations of fact, courts provide assurance that public debate will not suffer for lack of imaginative expression or the rhetorical hyperbole which has traditionally added much to the discourse of our nation. That is the case here. Considering the totality of the circumstances, including the general context of the statements, the specific context of the statements, and the statement's susceptibility of being proven true or false, a reasonable fact finder could only conclude that the statement was one of opinion and not fact. For the foregoing reasons, the court finds that the contested statement is an opinion that cannot serve as the basis for a defamation claim. Plaintiff has not shown a probability of succeeding on the merits of its defamation claims. Thus, the court grants the special motion to strike by defendants. Finally, because the court grants the motion, defendants may file a motion for attorney's fees and costs. The motion is to be referred to the magistrate judge. Because there is no set of facts that could support a claim for defamation based on Maddow's statement, the complaint is dismissed with prejudice. After defendant's motion for attorney's fees is resolved, the court will instruct the clerk to close the case. It is so ordered. Friday, May 22nd, Honorable Cynthia Beauchamp, United States District Court Judge for the Southern District of California. Amazing. Also not unexpected. We've seen the same ruling about Trump statements being rhetorical hyperbole. So Trump gets the same fair treatment that Maddow gets here. Everybody's being treated the same by the court system. So really interesting. Rachel Maddow is not culpable for defamation for saying that OAN employs a Russian-paid propagandist who also is paid for and employed by OAN. Anyway, let us know what you think in the comments below. Try to keep it away from the politics of it. We're not here to discuss the politics, and I reserve the right to remove any overly inflammatory political comments. It's fine if you want to make a statement about your politics, but keep it polite. Otherwise, I'll be removing the ones that go straight to ad hominem attacks and unnecessary arguments. We're going to try to focus on the legal educational part of this. Anyway, let me know what you think in the comments below. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and thank you for your financial support. This is a community-supported legal education channel that would not exist if it weren't for the monthly financial support of our viewers and listeners on patreon.com/ljfrench and sponsus.com/law. I love this huge list of $50 plus supporters that get shouted out at the end of our show. In May, the $50 plus supporters are Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And thank you to the $5 plus supporters. Everybody, including the $50 plus supporters, scroll on that LED panel and everybody gets a crawl on the end of the videos that drop. I'm Leonard French, your favorite copyright attorney. I hope everybody has a great week. Summer is just starting here in Pennsylvania, and I'm really happy to get out. I'm looking forward to the coronavirus restrictions being lifted at some point so I can go see my fiance and maybe even get married. Until then, I love you all, and I'll see you in the videos that drop. Bye. Into the bush and then down into the water bowl. Birds to it.
Tiger, I'll give
He wants to see if there's water in the other pool.